This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about the fact that allegations that establish breach of a condition will always defeat a suit, especially when the plaintiff puts in the facts that defeats his case, and why notice of a claim later than 60 days after expiration of a policy is too late, even when there is an injury at a massage center that causes a suit against a therapist. Injury that causes suits always, in my opinion, result in litigation. Hiscox Insurance Company moved the United States District Court to dismiss a suit for failure to state a claim because the insured reported its claim more than 60 days after the expiration of the policy. In Mluxe Williamsburg, LLC versus Hiscox Insurance Company, the United States District Court for the Eastern District of Missouri decided on May 22, 2025, that the plaintiff was his own enemy. This resulted from a case where the plaintiff, the operator of a massage spa franchise, entered into a commercial insurance agreement with Hiscox that provided liability insurance coverage from July 25, 2019 to July 25, 2020. On or about June 3, 2019, a customer alleged that one of plaintiff's employees engaged in tortious conduct, and the customer eventually sued on those allegations. Plaintiff made an insurance claim related to the incident, and Hiscox denied coverage. According to the insurance contract, plaintiff was obliged to give Hiscox written notice of any claim, quote, no later than 60 days after the end of the policy period, close quote. In a letter denying plaintiff's claim, Hiscox explained that plaintiffs first reported the claim to Hiscox on or about October 27, 2020, 94 days after the policy expired, or 34 days too late, and therefore the insurance agreement was not triggered, and coverage under the professional liability coverage part was precluded. Plaintiff sued, asserting that Hiscox's erroneous and vexatious refusal to provide coverage under the applicable policy without cause or excuse caused plaintiff significantly. Hiscox argued the vexatious refusal claim failed because plaintiff did not allege that it satisfied its obligations under the applicable insurance agreement. Specifically, the insurance agreement required plaintiff to notify Hiscox of its claim before September 23, 2020, and according to the complaint, plaintiff did not do so. Because the insurance coverage was never triggered by timely notice, Hiscox argued that its refusal to pay cannot be considered vexatious under the facts alleged, and therefore plaintiff has failed to state a claim upon which relief can be granted. In response, Hiscox contended that the purpose of a motion to dismiss under Rule 12b-6 is to test the legal sufficiency of the complaint. To withstand Hiscox's motion, plaintiff's complaint must contain sufficient factual matter which, when accepted as true and viewed in the light most favorable to the non-moving party, states a claim to relief that is plausible on its face. Factual allegations must be enough to raise a right to relief above the speculative level. A vexatious refusal claim ultimately requires plaintiff to prove 1. The existence of the insurance policy, 2. The insurance company's refusal to pay, and 3. Such refusal was without reasonable cause or excuse. The court concluded a vexatious refusal claim requires an allegation that the insurer's refusal is without reasonable cause or excuse. This element requires the plaintiff to show that it upheld its end of the bargain, as set forth in the insurance agreement. Failing to allege as much in the complaint provided grounds for dismissal under Rule 12b-6. Plaintiff's complaint contains no allegations, general or otherwise, that plaintiff complied with its obligations under the insurance contract at issue, mainly because it couldn't. A district court need not conjure up unpled allegations to save a complaint. Therefore, the court granted Hiscox's motion to dismiss. The court found, for various other problems with the pleading and the withdrawal of plaintiff's counsel, that the better course was to dismiss the entire matter without prejudice. Doing so allows the plaintiff sufficient time to find and retain new counsel, preserve plaintiff's ability to file a new complaint that sufficiently states a claim upon which relief can be granted, and gives plaintiff another opportunity to adequately serve all the defendants sued therein. Of course, if the facts remain the same, it's going to have a hard time. In my opinion, insurance law suits require a lawyer with knowledge of the minimal requirements of the law and the insurance contract. The complaint as originally alleged named a defendant who was not served, failed to allege a timely report of claim, and counsel withdrew before the motion was heard. By dismissing without prejudice, the court gave a plaintiff a second bite at the apple if it can find competent counsel to file a better suit, and if, of course, it could show that it complied with the policy terms and conditions. A trial court in this case was being kind to the plaintiff and giving it another chance. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you will have access to the more than 5,050 blog postings. You can also subscribe to these videos at youtube.com or rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider subscribing to my Substack publication for a very small fee. And finally, please tell your friends and colleagues about this blog and these videos so that they too can subscribe. Thank you for your attention.